The topic we will be exploring throughout this video is the issue with algorithmic personality testing as a hiring tool, which is one that affects all people wishing to be a part of the workforce, but specifically all prospective employees who hope to enter employment areas that have already enacted strict use of algorithmic personality testing in order to vet their candidates. Now, though this issue has proven to be affecting wide-ranging groups of people, it heavily affects marginalized groups at a much higher frequency, specifically those who struggle from mental illness or have struggled in the past. My chosen chapter from Weapons of Math Destruction by Kathy O'Neill highlights in particular one story, that of Kyle, a well-qualified young man with bipolar disorder who is blacklisted upon applying through companies which use personality testing or mental health screening as a main facet of their employment process. As highlighted within my essay, we will analyze discourse from the issues raised in Soroka v. Dayton-Hudson Corporation to delve into the historically oppressive nature of these tests and the use of them, not only on the basis of mental ability, as talked about within O'Neill, but of gender, ethnicity, political affiliation, and nationality. At a specific county of California level, our stakeholders can be represented by both the plaintiffs and the defendant of the Soroka v. Dayton-Hudson Corporation case, which took place from 1989 to 1993 within Alameda County, California. Both the corporation and the prospective employee hold a stake in the use of personality testing as a hiring tool, both due to the financial benefit it provides the corporation and the detrimental effect it has on people who simply need to work to make a living. The Dayton-Hudson Corporation is a conglomerate which owned and operated multiple department stores at the time of litigation, including but not limited to Target, Marshalls, and Mervyn's, and this corporation is only one of many which uses personality testing or a mental health screening as a hiring tool. The case involving Target within Alameda County and plaintiffs Sibby Soroka, William D'Arcangelo, Susan Uri, and Robert Martzetta exemplifies the historical and continual discrimination against people on the basis of gender, race, sexuality, nationality, ethnicity, and ability, and within this video, we will delve into the case of Soroka v. Dayton-Hudson Corporation in order to further understand not only the use and function of personality testing within corporate spaces, but the multifaceted discriminations provided by such use. As presented by O'Neill within her introduction to Weapons of Math Destruction, the author notes the detriment that the acceleration of computational math and data has caused on the function of our society, and discusses the effect of being aware of such in the context or world of computer science and technological advancement versus the effect of being discluded from and by those with power in society. Such advancement highlights a dire necessity for being informed of and understanding the roles that math and technology play within our society. That knowledge is indeed powerful in the context of inciting necessary algorithmic reformation, and is only truly available to those who are privileged enough to be aware of such bias and are actually able to overcome the obstacles in place. As AI use evidently increases greatly in all sectors of large corporate spaces, the awareness of such technological advancement is vital to understanding what kind of environment one is even attempting to either enter or exist within. This may have been a large factor in the Soroka v. Dayton-Hudson Corporation case, as the early 90s was an era of technological advancement, and the psych screen evaluation was perhaps an incredibly new phenomena to the applicants at this time. The unfamiliarity puts applicants in a very vulnerable position when attempting to correct injustice, as these tests and the use of AI in corporate spaces was incredibly new and made it a lot more difficult to spot wrongdoing or blatant bias. Within the chapter of Weapons of Math Destruction that I chose for analysis, titled Eligible to Serve, we are able to view the ways in which being informed and privileged to have access to resources and familial support are certainly factors which make it possible to at the least share one's experience with algorithmic bias and enact a conversation about the issue within communities striving for justice. Furthermore, O'Neill follows her introduction with an analysis of statistical gathering, organizing, and reasoning within her first chapter of Weapons of Math Destruction, titled Bomb Parts: What is a Model? She compares the algorithmic alterations made to the gameplay of baseball to the implementation of the model, which she describes on page 23 to take what we know and use it to predict responses in various situations. She describes that in baseball, there was a player who would constantly hit line drives straight to a difficult area to get to. Now, in order to combat this, the players on the opposing team decided to change their formation, which they would then shift into whenever he would come to bat. This reformation was so successful for them that they began adopting this technique with more and more players, and as time went on, this reformation just became a very common tactic in the gameplay of baseball for all teams. O'Neill emphasizes this change as without great benefit or detriment for either team when it was being applied, as the utilization of this technique was designed for only one person's hitting style. Therefore, this analogy highlights a discrepancy of the efficacy of the model as being subject to human volatility. Within the context of this video's issue, we can identify the model that the author speaks of as the personality test being administered by these corporations. However, within this context, there certainly is a beneficiary and a negatively impacted group. Now, pulling from Wayne Camera and Peter Miranda's journal titled Using Personality Tests in Pre-Employment Screening, Issues Raised in Soroka versus Dayton Hudson Corporation, the authors provide a detailed description of the case, which took place in Alameda County, California, and was filed on September 7, 1989. The lawsuit was filed by Sibby Soroka, and the case was subsequently joined by plaintiffs William D'Arcangelo, Susan Uri, and Robert Martzetta in the following years, who had all applied for security officer positions at a Target department store in Alameda County, and were all denied without notification of reason. The plaintiffs claim that they were each faced with a psychological test administering multiple questions attempting to allude to the plaintiff's sexual orientation, political affiliation, and religious belief, although a multitude of the state of California and federal laws, including the Civil Rights Act of 1964, prohibit inquiry prior to employment on the basis of such. The PsychScreen psychological screening test was created and initiated by Target and an outside consultant a few years prior to the case in 1988 in order to identify personality traits that coincided with being a sufficient security officer, specifically one possessing good judgment and emotional stability. This journal also contends that each test was administered to applicants who had not been screened out due to their written applications and interview, references, or background checks, meaning that these prospective employees were already deemed qualified based on their interviewing skills and/or their activity in the workforce prior to screening. The results of the screening are then sent to an outside psychological consulting firm along with the applicant's information regarding their race, ethnicity, gender, and age. Target then received back a PsychScreen evaluation sheet which scored, interpreted, and evaluated applicants' protocols on 5 psychological constructs, being A. Emotional stability, B. Interpersonal style, C. Addiction potential, D. Dependability or reliability, and E. Socialization, which they talk about on page 9 of their journal. Although this is not the same specific personality test evaluation as administered within Kyle's experience, the 5 psychological constructs of a model employee, as demonstrated within this journal, strongly correlate with those presented in Kyle's story. As discussed within personality testing in the Americans with Disabilities Act, cause for concern as normal and abnormal personality models are integrated by Arturia Melson-Silliman et al., people with mental illness tend to possess complications with at least one of each of these constructs, if not all of them. And not to mention that each of these factors of personality are greatly impacted by one's upbringing and environment, and should not be seen as a full deterrent from employment, especially when a personal connection or interaction has been made prior. Going back to O'Neill's analysis of the model as discussed within her first chapter, the phenomena she's talking about is highly important in analyzing these instances of litigation as a result of unlawful psychological screening. This is because these algorithms have been formed on the basis of prejudice and bias and have further been reformed and reworked in order to conceal their effect on marginalized groups. This has resulted in a shocking lack of litigative instances, as people who have been turned away due to the screening process are very rarely ever notified of their status. Additionally, the veiled and convoluted matter within these tests are weaponized to carry on the concept of the ideal worker in our capitalist society as one unaffected by emotion, stress, and any other normal human experiences that are simply unavoidable in a day-to-day job. Both the story of Kyle Bem, as discussed within Kathy O'Neill's Weapons of Math Destruction, and the case of Soroka versus Dayton Hudson Corporation, as discussed within both Arturia Melson-Silliman and Wayne Camera and Peter Miranda's journals, clearly exemplify the illegality of many large corporations' hiring practices, and are today both viewed to be quite notorious cases. This is due to both the quiet nature of the settlement within the Soroka versus Dayton Hudson Corp case and the long-standing unclosed pending state of Kyle Bem's suit. Personality testing as a basis for employment has time and again proven to be discriminatory to marginalized groups with minimal effort for true algorithmic reform. The basis for all personality tests must be entirely reworked in order to eradicate algorithmic bias, which is entirely prevalent and obvious within the matter of these screenings.